Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And in any given week, as I would normally say, there, there are always a number of issues worthy of discussion. Tonight is no different. I want to begin by extending good evening to all those viewers who are joining us on television in West Coast, Berbice, Mahaika to Rosignol to Blairmont, Ithaca, and beyond. Welcome to another program of Issues in the News. To those of you who are joining us on the east bank of the Berbice River, New Amsterdam, all the way to Kanji, and of course along the Quarantine Coast all the way to Molson Creek, and as far as Siparuta. Good evening. You are joining us on television. Good evening and welcome to another program of Issues in the News. To those of you who are joining us on Freedom Radio, good evening and welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you who are joining us on Facebook Live, on different platforms across Guyana, the Caribbean, North America, Europe, Asia, and further afield. Welcome to another program of Issues in the News. And I invite you, as I would normally do, to press that share button on your telephone, press that share button on your computer, so that as many persons as possible join us in tonight's discussion. When you share that program, all the persons on your page, all the persons on your Facebook account would be able to join in tonight's discussion. So share that program so that we can have the widest possible audience. And I normally would recognize a few persons to get you engaged and get you enthused and bring you into the program. Mark Wilson, Norma Gayadin, Rajan Datadin, Carla Thomas, Herman Bacchus, Madbar Singh. I saw Kayum Yassin, Jasmine Ramdat, Empress Blackman, Ramchan Sukai, Chitra Sukraj, Ali Ahmad, a regular on this program, Krishna Dan Paul, Horace Sarkar, Teresa Arifa, Devi Singh, and so many of you. Welcome to another program of Issues in the News, and please let me have your views, let me have from you issues that you would like me to address during the course of the program. Again, please share the program so that as many persons as possible, your friends, your followers, etc., can join us in tonight's program. It is now public knowledge that Monday coming, our Minister of Finance, the Honorable Dr. Ashni Singh, will present our government's 2023 budget in the National Assembly. And that budget, of course, will contain our developmental plans and our financial and fiscal plans and arrangements that will unfold in the year 2023 and beyond, and will lay out the developmental plan that we have for the country during the fiscal year of 2023 and beyond. It's a very, very important day in our national calendar, and I ask all of you to tune in to Dr. Singh's presentation from the National Assembly, and I'm sure that you will not be disappointed. You will hear of our government's developmental plan and how we intend to finance that plan for the year 2023 and beyond. It is a significant event in the calendar of any country, the national budget. And of course, ours will be presented very early, that is, Monday coming. So as far as possible, we have as much time during the remainder of the year. Of course, the budget will have to be, after the budget is presented, normally The debates in the National Assembly will begin in respect of the budget the following Monday, and then that will last for a period of approximately 1 week, and then the consideration of the estimates will begin in the Committee of Supply, and that will last for another week. So we will not be able to have this program while I am in the National Assembly. As you know, during budget presentations and debates, Parliament begins to sit at, or rather the National Assembly begins to sit at 10 a.m. and it goes sometimes very late, sometimes into the next morning, depending upon the agenda and the rate at which the proceedings are carried on. Hopefully, we will have constructive debates, we will have inputs from the opposition of a constructive nature, and we hope that there will be orderliness and there would be decorum from all sides in the National Assembly, and we would be able to get over the very important business of presenting and approving the national budget of our country for the fiscal year 2023. I want to offer some comments on a decision of a High Court judge which was delivered, I think, on the 28th of December last year. In that decision, which was widely carried in the press, the Honorable Judge ruled that there is no provision in the laws of Guyana which allows members of the Guyana Police Force, and by extension, the immigration authorities, from prohibiting anyone from leaving the jurisdiction of Guyana. It is a decision that has raised widespread concerns in the public domain, and of course, we disagree with the decision, and we have since lodged an appeal at the Guyana Court of Appeal in respect of the decision of the learned judge. But a lot of persons have asked me to explain why we disagree with the decision. Now, and I will attempt to do so very briefly, because a lot of our people are interested in law and they are interested in freedoms. And of course, the judge took the position that the restriction on persons to travel is a contravention of their freedom to travel. Of course, the Constitution of Guyana guarantees everyone as a fundamental right and freedom the right to travel throughout Guyana as well as to leave Guyana. That right is embodied in Article 148 of the Constitution of Guyana. So no one can dispute, and no one is disputing. I certainly acknowledge that there is such a right to travel throughout Guyana and a right to leave Guyana, which right is enshrined in the Constitution of Guyana. Like every right in any part of the world, that right is not absolute. That right is subject to certain conditionalities and or restrictions. And that is the position in every country in the world. Any right that is absolute, that is unfettered, such a right will lead to anarchy. Rights are always circumscribed so that others, or the rights of others, are protected and preserved. So you have a right to speak. You have a right to express yourself by speaking, but you do not have a right to libel, slander, and character assassinate others. You have a right of movement, but you do not have a right to drive up a one-way street. And I can continue to give you examples of how rights are restricted. You have a right to speak, as I said, but you do not have a right in a crowded cinema to shout fire, fire, because that can lead to danger, that can lead to stampede, that can lead to the injury of others. You have freedom of expression and you can play your music. But if you play your music so loudly so as to cause a nuisance to another, your neighbor, then that is a violation of that neighbor's right not to hear your music. So the law has to balance these competing rights and strike a delicate equilibrium for the public good and what is regarded as the public's interest. So every right, every fundamental right and freedom is subject to certain conditionalities. Every civilized country in the world must have, as a matter of sovereignty, a power to prevent a person or certain class of persons from leaving the country or from moving within the country. That's a necessary state power. Of course, the right must be stated expressly somewhere, possibly in the Constitution, and of course, it must be grounded in reason. So, there was this person who was attempting to leave the country, but the person was charged with an indictable offense and was granted bail. And as a consequence, the person was put on a list of persons prohibited from leaving the country. Why? Because when a person is charged with an indictable criminal offense, that person is in the jurisdiction of the court. Now, if that person pleads not guilty, the court has certain options. The court can refuse bail or can grant bail. If the court grants bail, if the court refuses bail, then that person is handed over from the custody of the court to the custody of the prison authorities and shall be held in remand until the person is required to return to court. If the person is granted bail with surety, it means that the person is in the custody of that person moves from the court over to a bailor, that is, the person who will pay the bail. And that bail is lodged as a surety. Now, there are certain inherent principles upon which that person moves from the custody of the court to the custody of the bailor. And those conditionalities are that the bailor must keep that person within the jurisdiction of the court, so that and to bring that person back to court at the time when the court fixes a date for the return of that person, or at any earlier time that the court may require the person to return. And why the person must always remain within the jurisdiction of the court? Because if the bailer allows the person to leave the jurisdiction of the court then that bailer will be unable to discharge that obligation of producing that person to attend court at a given time. The law doesn't allow the bailer to make a decision that the person can leave the jurisdiction and leave the custody of the bailer. Remember, the jurisdiction of the court is confined to Guyana. And a person on bail must always be in the jurisdiction of the court, unless permitted to leave by the court itself or by a superior court. And that is why persons who are charged with an indictable offense are required, or is required, a person who is charged is required, if they wish to leave the country, to get an order of court to leave the country. Because when they are granted bail, they are released from the custody of the court into the custody of the bailer, but they must remain within the jurisdiction of the court. And the jurisdiction of the court is within territorial Guyana. Criminal courts, the jurisdiction of criminal courts in Guyana is territorial. That principle is captured and inscribed as a condition or a restriction in the Constitution to the right to travel overseas. So you have a right to travel overseas subject to a person being charged with a criminal offense and granted bail with surety. And that is expressly stated in the Constitution. Another category of persons who are similarly restricted are those who may have a contract with the government, which contract stipulates that during the currency of that contract, while that contract remains valid and enforceable, that person cannot leave the jurisdiction of Guyana. Because if they are permitted to leave the jurisdiction of Guyana, they can flee. And their contract becomes frustrated. They breach their contract. A person who is charged with a serious offense, an indictable offense, and who is granted bail and is not restricted from leaving the country can flee and not attend the trial. And that violates the condition upon which bail is granted. It destroys the whole basis of bail. And that is why these categories of persons are expressly recognized in the Constitution as restrictions to the right to travel or the right to freedom of movement. And the position which I have just articulated are not new positions. They have been ruled upon by courts in Guyana, both the High Court and the Court of Appeal. Judges of the caliber of former Chancellor J.O.F. Haynes has rendered a written judgment on this very matter, outlining the law and explaining how the right to travel is lawfully restricted by the Constitution in respect of a person who is charged with an indictable offense and granted bail with surety. So what happens is that such a person is put on a list at the airport so that the immigration officers can have a database of persons who are lawfully restricted from leaving the country. Unfortunately, that database is labeled or enjoys that unfortunate label of a blacklist Blacklist has a negative connotation. And perhaps historically, when we were in an age of authoritarianism in Guyana, when you had political dictatorship under the PNC from 1968 to 1992, the PNC government indeed used to unlawfully put persons on that list and restrain them unlawfully from traveling. Many political leaders were put on that list unlawfully, not because they committed any offense, not because they were in any of the categories in the Constitution prohibited from traveling, but simply because they were in the political opposition. Many leaders of the WPA, in particular at the time, and the PPP, Walter Rodney, and a whole long line of them, were once placed on that list, or any person that the PNC felt they wanted to keep in Guyana, were put on that list unlawfully. And it is during that time that that list got the name Blacklist. But under our government, in a democratic society, persons who are not to be on that list are not placed on that list, at least not intentionally and not as a matter of policy of government or state. You may have one or two persons there who may have been placed there by error, but by and large, once the Constitution allows it, it is an important facet of the criminal justice system, and it's an important part of state power to have persons, to have a database compiled of persons who are lawfully prevented from traveling. And that is the list that the immigration officer sometimes will have to make reference to ensure that persons who are not permitted to leave the country leave. How else would they know? They can't walk around with the information in their heads. So there is a list generated by the various state agencies that are charged with the responsibility of ensuring that such a database is kept, and that database is handed to the immigration authorities. So I thought that I would explain that issue which came to fore in the judgment of the learned judge, and to explain why we have filed the appeal and why we are challenging the decision of the learned hearing judge in that matter. The matter is fixed at the Court of Appeal, and we have also filed a motion to ask the Court of Appeal to bring up the appeal so that it can, to have an early hearing of the appeal. Because this case has, this decision of the learned judge has far and deep reaching ramifications for the criminal justice system. You have hundreds of people who are on bail, charged with indictable offenses. They can now flee and may not return for their trial. You have hundreds of persons who owe obligations to the state and are bound by contracts to remain here. And the Constitution provides that in such a case, those persons can be restrained from leaving the country. And it is a term of those contracts that they can't leave without permission of the government. It's not that you are absolutely prohibited. For those who are charged and placed on bail by the courts, the court can give you permission to leave. Those who have contractual obligations with the government can give you permission to leave. It's not that you are absolutely prohibited, but there is a process. And unless you comply with that process, you ought not to be permitted to leave by law, by the supreme law the Constitution. So I thought that I would shed some light on that matter, as many persons have asked me, both on Facebook and personally, to speak on the matter and explain the decision of the learned judge, or explain at least why we have appealed the decision of the learned judge. So I have attempted to do so in the simplest and shortest possible manner. The next issue that I want to deal with is the mocker squatting issue, which we witnessed last week. A very unfortunate incident. So the facts are well known, but let me rehash the facts for the purpose of this program. The information are all in the public domain. Since 2008, the government of Guyana began to engage persons who are squatting on state lands in the Mocha area, and has requested them to move because of the government's plans since 2008 to construct a highway where those persons are living. So this is not a recent incident. This matter is of some vintage, dating back to 2008. For whatever reason, the government did not proceed with the plan and the government resumed the project of constructing that highway in 2021. Again, the government in 2021 began an engagement with those persons. The government enlisted the support of the Neighborhood Democratic Council and began to engage the residents. There were about 28 families whose properties, who were occupying this land that was identified for the construction of the highway. I want to make it absolutely clear. These persons do not own the property, the land. They do not own the land. Of course, they squatted, which is an illegal act, and they constructed buildings on the land, which buildings are also illegal structures. They may have been there for a long time, but we passed a law since 2010 which prohibits persons from getting prescriptive title by longevity of occupation of state lands or public lands. So public lands and state lands cannot be the subject of prescriptive title application. It's absolutely prohibited, and that occurred since 2010. So the issue of prescriptive title does not arise, because that's not permitted anymore in respect of state lands or public lands under the laws of Guyana. Government began an engagement with these people, offering house and lands in close proximity. In fact, the next community, Horstelling and Farm, house and land is being offered with title. These are squatters, they don't own the land, And here it is that the government is giving them land and the house on the land and the freehold title. Government has also offered compensation to the value of their structure, has offered them help to move the structure, has offered them separately monies to compensate for any damage arising out of the movement. In this regard, $260 million have been paid, has offered them lease land in close proximity for them to continue whatever farming activities they were engaged in. Government offered compensation separately for crops affected, yet persons were refusing to move. Out of the, I think 28 moved and 7 remained. No government would want to bulldoze people's property. No government. And that must always be a measure of last resort. Is it fair, having regard to the tens of thousands of people who are affected because there is a singular roadway on the east bank of the Amarara? Is it fair that those tens of thousands of persons must continue to be affected because 7 persons are refusing to move for the construction of an alternative roadway to bring relief, to bring reprieve, and to bring convenience to tens of thousands? Is it fair to put a halt on national development because of 7 persons who have no color of right to be on the state's land and who are refusing compensation in the tune of millions and all the other help that I have referred to? These are not people who are being put on the road. These are not people who are handed money alone. They are given money, they are given house, they are given land, they are given titles, they are given lease land for the animals and crops, they are assisted in moving, and they are being compensated millions of dollars, hundreds of millions of dollars for the inconvenience and other damage caused for moving. Which government in a society governed by the rule of law will tolerate this type of obstruction? Tell me. The opposition again had a glorious opportunity of offering leadership. What did they do? They turned up there and tried to throw gasoline on fire. They tried to incite the people. They tried to encourage the lawlessness, contribute to the lawlessness, and as night follows day, injected the racism, because that's all they can do. All they saw were Afro-Guyanese houses being bulldozed. That's all they saw. It mattered not that tens of thousands of Afro-Guyanese would benefit from this very roadway that was going to be constructed. And these matters must be carefully analyzed by objective Guyanese, so that the truth, so that you can make your own judgments based upon the facts. Now, moving persons for the purpose of national development is nothing new to Guyana or in any country. Moving persons, acquiring property for national development has always been part of the repertoire of powers that a state must necessarily possess, and when the occasion arises, the state must be able to exercise it in the public's interest. Norton and the APNU descended upon that event like sympathizing Judas, for want of a better word. They forgot what the PNC did to squatters in the 70s, right across Guyana. In the 70s, at the back of Metamir Zorg, south of the railway embankment, dozens of homes were bulldozed by the PNC. It's a place now called Prem Nagar. Prem Nagar. That's the place at Metamir Zorg, south of the railway. People's houses were bulldozed by the PNC. They were never served notices. They were never engaged. They were never offered compensation. Bad settlement. I remember growing up as a child. In the 70s, there was an area in Bad Settlement that was flooded and bulldozed by the PNC government. Older persons listening to this program will know what I'm speaking about. Many may have endured it. Compensation was not offered. Right here in Sophia, in the late 80s, early 90s, when squatting began at Sophia, Desmond Hoyt administration flooded Sophia. The police went there with police dogs and loosed it on the people. Right there, right at Sophia, right behind Congress Place, when the people were squatting. When the PPP got into government, we began a regularization process at Sophia. And today, Sophia is one of the largest housing schemes in Guyana. Never mind they don't vote for PPP. They will never forget, however, that Hoyt chased them out there. Hoyt loosed dogs on them. Hoyt flooded that area, and the PPP government regularized it and gave them title. That is the history of Sophia. Someday, I am hoping that, people will come to their senses in this country. Do you know how many times the PPP had to do this in relation to Indo-Guyanese and Afro-Guyanese, and did it peacefully? We have regularized hundreds of squatter settlements across the length and breadth of Guyana. Hundreds of squatter settlements, meaning villages that existed since indentureship and before that, but no title was given. And people were living there as part of the housing program. From 1992, we began a squatter regularization program and had to adjust, had to work with people to adjust their boundaries in dozens and if not hundreds of communities across this country. And we did so in collaboration with those people. We helped them, we compensated them. You know how many houses we had to move before streets could have been demarcated? Because persons were squatting and they were living in the middle of a street. You had to move those people right across the coastline I'm speaking about. And we did so. The persons affected were Indo-Guyanese and were Afro-Guyanese. What the PNC sought to do there at Mocha was to speak about the race of the people, not recognizing that Indian people have had to go through that, hundreds of thousands of them, right across the country, and Afro-Guyanese as well. Persons would recall the dozens of people that we moved from the railway embankment right there at Kitty, right there at Lamaha Street. You know how many people were squatting there? Indo and Afro-Guyanese. We moved all of them, gave them house lots, and assisted in moving them. You know how many dozens of persons, squatters in Tiger Bay, Afro-Guyanese, whom we moved, put some on the East Coast at Belfield. There's an entire community at Belfield that moved from Tiger Bay under the PPP government. And we also moved some to Parfait Harmony and other parts of the country. We gave them building materials, gave them house lots. And that's how they moved from the railway embankment and moved from Tiger Bay. And when we were doing developmental works on several mega projects, we had to move landowners. I'm not talking about squatters now. Move landowners. These are people who own the land and they're living there for decades with their houses. And we move them in the public's interest. There is something called the doctrine of eminent domain in the United States that allows the state to acquire private property for a public purpose if the land is required for national development. Eminent domain. Well, we have that in Guyana too. It's captured in our legislation called the Compulsory Acquisition for Public Purpose Act. It allows the state to seize property and pay market value compensation. During Barnum years, they used to pay a 1939 valuation. And Barnum, it is a notorious fact that the Forbes-Barnum government seized valuable private properties from people for no reason at all. Tacuba Lodge, the Sankara Estate, and many, many places I can call. Where Citizen Bank used to be on Camp Street, Central Prawn Bokery, and a whole set of places I can call, and pay those people a 1939 valuation, because the law had said that then. The PPP government changed that law to allow for market value to be paid. You must understand the transformation that we have done to this country to ensure that people's rights are protected, people's proprietary interests and other rights are protected. We changed that 1939 valuation that was in the law and we made it current market value. So when we were building the Borby's Bridge, for example, on the western bank of that river of the bridge at the Edward Village, we moved dozens of people and paid them compensation. And we sat with them and negotiated as we tried to do with the Mocha people. And they don't own the land. They don't own it. The people at the Edward village owned it by transport. In fact, Moses Nagamutu was retained by our government. He was in the PPP at the time. Moses Nagamutu was the lawyer for the government who negotiated with those people and got settlement for each one of them upon the government's instruction. And that is how we were able to move those people so that the Berbice Bridge could have been built under the Edward side of the river. When we were building the Hope Canal on the east coast of Demerara, dozens of private lands had to have been purchased and persons moved because they were in the pathway of the canal, from the Conservancy all the way to the seawall. Again, I think Moses Nagamutu was retained. And we compensated every one of those persons. 90% of them were Indians. And we took their lands for national development. We didn't have to use a bulldozer. We didn't have to use a force. Currently, where the Gas to Shore project is going, it is reported in the newspapers on a regular basis. The Gas to Shore, the pipeline is running from Crane Seawall all the way past Wales Estate. Dozens of miles of private property have to be acquired, and we are acquiring it. Most of them are Indo-Guyanese. And these are people who own the land, they're not squatters. And they're not resisting. They don't want to sell. They don't necessarily want to sell. Because some of them are earning their livelihood on those lands. Several miles of those lands are farmlands. And these people own these lands by transport. We have a team of lawyers working, and we are negotiating a consensual arrangement with each of those persons. And they are cooperating, and they are moving. But 6 squatters, I understand 4 of them out of the 7, have been now engaging the Ministry of Housing. So only 3 left. So 3 persons must stop national development, whereas hundreds of others are working with the government to achieve national development in the best interest of everyone. Don't you think Afro-Guyanese will benefit from these national developments? Where the Demerara Harbour Bridge is going, where the new Demerara Harbour Bridge is going. Again, persons, private property are being affected. And again, we are negotiating with them to ensure that we acquire their property in the public's interest. But we are doing it consensually, and they are cooperating. And these are owners. These are people who have houses that value millions of dollars in that area where the bridge is going to fall. And the road from Schoonard to Parika, that's an entire highway. Do you know how many private properties that road will now take up? Those persons have already been engaged. They own those properties. They're not squatting. And they are negotiating peacefully with the government so that we can acquire those lands, so that Guyana can benefit from a new highway from Schoonard to Parika. Guyana can benefit. And you have three persons obstructing an entire highway at Mocha, and the opposition is lending support to that. My friend, that I don't think you can have a better exemplification of the destructive role that this opposition is playing. And what makes it worse is because of its history, this opposition's history when it comes to people's rights. I've already made reference to Burnham's attempt, not attempt, but Burnham's many compulsory acquisition of people's property and paying them at 1939 value. And he didn't have good reason either. He didn't have good reason either. Why did he take Sankara estate, the Hope estate? He couldn't build another estate. We have abandoned a lot of lands in close proximity to there. What was the national development at Sankara's estate? To seize the people's estate and pay them a pittance. But let's say that's 4 decades ago. Many of you will remember in 2017 when the then Attorney General Basil Williams attempted to compulsorily acquire the land of Bihari, the Bihari group of companies, and Clarissa Reel, next door to the Attorney General chambers at Carmichael and Middle Street, in broad daylight, without even telling the people. Without even telling the people. He was moving to compulsorily acquire those people's properties in a surreptitious way. I remember just reading the official gazette and seeing the advertisements. I call it Stabrook News, I remember distinctly, and I made it public through a reporter at the Stabrook News. That is how that issue came to the fore. And Clarissa Reel was a member of the PNC, well, perhaps still is a member, was their High Commissioner to Canada. He was attempting to steal Clarissa Reel's property by compulsory acquisition. Who was a member of their party and was representing their government in Canada as the High Commissioner. And he was doing the same for Bihari property next door. And that only happened in 2017. The Attorney General of APNU, AFC government. And these people now want to masquerade as protectors of private property and want to play the race card and make it a racial issue when it has nothing to do with race. I appeal to the 3 families who are still to enter into negotiations with the Ministry of Housing to do so quickly. It is crazy not to do so. It is simply an act that is inexplicable not to engage the ministry. They're even spreading a rumor that the animals were killed. That is not true. The Ministry of Agriculture, through the agency of NARI, was engaged, and arrangements have been made in relation to the people's animals. They said all sorts of rumors and propaganda they have been spreading about those people's animals, etc., that the animals were buried in some hole. Not true. But that's the wickedness. And they could have lent leadership to those people. They could have lent leadership for those people. What have they done? The people properties have already been demolished. Where are they now? They are homeless. You think Norton can provide them with anything? They are homeless now. What can Norton do for them? What can the APNU AFC do for them? Absolutely nothing. Absolutely nothing. So, my friends, that is the type of leadership that the opposition is offering Guyana. I am preaching here every Tuesday, and I hope that something is sticking, in particular to the opposition supporters, that they can see sense. I can only take the horse to the well. I can't force the horse to drink the water. My friends, we have come to the time where I have to bid you goodbye. I want to thank you very much for spending the last hour with me. I think that it was important that I delve into this Mocha issue, deal with the legal issues and deal with the historical matters connected to this, and to show the destructive role that the opposition is playing, the opposition political party is playing, and to illustrate, as I will continue to do, that they are not leading. They are the worst enemies of their own supporters. They are the worst enemies of their supporters. On that note, my friends, have a great evening, have a very successful week, and I may not be able, yes, I'll see you next week, and we will continue our discussions. Thank you very much, and enjoy the rest of the evening.